Losing a loved one is very painful, it's very distressing, and it's more traumatic when you learn that your loved one died as a result of medical negligence or medical malpractice. And the cases of medical negligence are on the rise in Kenya. I am Wakili Kiti, an advocate of the High Court, and this is Law 254, your favorite legal show that seeks to demystify the law, give you useful tips and guidance on how you can interact with the law, basically putting the law in your hands. Today we want to discuss medical negligence. So for a start, you would ask, why should you pursue a medical claim when the person concerned is in fact dead? And quite more often, pursuing legal proceedings, pursuing a legal recourse might be draining financially, emotionally, and it's just a draining encounter. But you might ask, why would you go down that route? Number one, it's because you want to seek justice for your loved one. You want people to be accountable. Number two, maybe the person who has died had a financial bearing on the family, and by him exiting the picture, then your family is visited by financial strain. So you would want compensation for that. Number three is just exercising your civil duty as a prudent Kenyan so that other families don't go through the same anguish that you went through. So those are some of the reasons that you would want to pursue a medical negligence claim. And you might ask also, who is entitled to pursuing this? Under the Fatal Accidents Act, anyone who's beneficially interested in that matter might pursue the claim, namely the family members, the parents, the sisters, or the estate of the deceased. The executor or the administrator of the estate of the deceased might want to pursue the claim for a negligent claim. And these cases of medical negligence have been on the rise, as I said, and the most recent case is that one of Ethan Mwendo, who was injected by an overdose of morphine. Very, very, very unfortunate case. We want to break down what constitutes medical negligence and how do you as a family prove this. So to start with, and I think this is good news, is medical negligence evidence is based on a preponderance of evidence and not burden of proof. What I mean is, beyond reasonable doubt burden of proof. What I mean is, there's a lower threshold. The law appreciates that as a victim of medical negligence, it might be hard to get some sort of evidence, very cogent evidence to support your claim. And because of that, then the burden of proof is not that of reasonable doubt as expected in criminal proceedings, but rather on a preponderance of evidence. It's a lower threshold. So that's good news. So if you have a medical claim, don't you worry about how you're going to prove it. But let's understand what a medical negligence is. So a medical negligence claim is based on the actions of a medical practitioner that fall below the threshold of an expected proficient and competent medical practitioner. So if you go to a hospital, there are some expectations that you have. One, that the hospital will have the right equipment to treat you. Two, that the medical practitioners will have the skills requisite to treat you. Three, that they'll be competent and proficient in whatever they're doing. So whenever they fall below that threshold and that occasions you injury, then you have a medical negligence claim. So what do you need to prove in this? Number one, that there was a doctor-patient relationship. You will need to prove that there was a relationship between yourself and the hospital or a doctor, that they owed you a duty of care. This is usually not very hard to prove because quite more often all these medical procedures do not happen outside a medical establishment. So long as you went to hospital and you were treated, then there is already a relationship. There is already a doctor-patient relationship or a hospital-patient relationship established at that point. So that's not easy. That's not hard to prove. The second thing is that you need to prove that the doctor acted in a negligent manner. And how do you prove this? The doctors are expected to act in a particular standard. So if a certain procedure would have been done differently with another doctor of a similar standard in the same circumstances, then it be held that this particular doctor was negligent. How is this proved? Another medical practitioner would come and say that in these circumstances, this doctor ought to have done ABCD, but because he did not do ABCD, then whatever consequences happened. So you have to prove that the doctor failed in their standard of duty to you. Number 3, you have to prove that the injury was caused as a result of the doctor having not met that threshold. So if the doctor did not meet the threshold, but in fact you had underlying medical conditions, that might not help you. That might not be very strong for your case. You need to prove that there was no other medical condition that would have occasioned the consequence that ensued, save for the doctor's negligence. And then number 4, you need to prove that you suffered loss. You know, that as a result of his negligence and as a result of that negligence causing you injury, that you suffered loss. Either you cannot proceed with working, or someone died, or you lost, there was a financial loss that you incurred as a result of treating the injury, etc., etc. So those are the conditions upon which you need to prove that the medical negligence case happened. I would also want to explore some of the documents that you need. Number 1, you will need to have the medical report. It's very important. This medical report is usually given to you for free for a reasonable duration of time. When you go to a hospital, once they onboard you, they take some notes, the conditions upon which they found you in, and those notes will be used when you're trying to prove your medical negligence case. Number 2, you might also want to have a postmortem. So if a person died, don't msikimbilie tu kuzika without having conducted a postmortem. It's important that you do a postmortem so that it goes on record the cause of death of that person. If you don't have a postmortem, then you can conduct an inquest in court using a coroner. But why go through that process when you can just have a postmortem conducted on the deceased? Number 4, you will need financial documents. If this person was earning a salary, you will need to produce pay slips. You will need to produce bank statements. You will need to produce receipts if you made payments to hospitals, etc., etc. So those are the documentations that you need to prove your medical negligence case. And after you have successfully proven a medical negligence case, then you are compensated for the damages. So the damages, as I said, could be for special damages, that is for everything that you spent as a result of the injury, or it could be a general damages, just the loss of love, the loss of a companion, the loss of financial benefit that you're getting from the deceased, etc., etc. So as always, we at Law 254 will always be ready to give you useful tips on how you can handle certain things that happen to you on a day-to-day life. And it is very important that medical practitioners take responsibility, because if you're losing a loved one as a result of someone else's negligence, that is very, very unfair. You should be held accountable.